everyone. Welcome to this new webinar. My name is Maria Giuffrida. I'm from Trust IT. Together with me today we have Sabrina, my colleague from the same company, and Bjorn Lundell, our speaker. And we are in the context of the EU-funded project EDU4Standards. I have a few slides to introduce today's webinar, which I will share in a moment. So you should see the presentation now. So we have started a few weeks ago a series of webinars on the topic of the green and digital transition. The webinars are only a part of the materials we have available on this topic, because we also have other type of resources like videos, slides, etc. And the aim is to complement, let's say, the mission of EDU4Standards with this new stream of outputs on this, very, very current topic. And for those who don't know yet, EDU4Standards is a CSA, Coordination and Support Action, started in 2024. It will end at the end of 2026. So we are in our final months. And the main objective of EDU4Standard is basically to make the education world and the standardization world meet. We have developed an innovative teaching concept for standardization, explaining how to embed standardization into education at various levels. This concept has been tested at higher education levels via pilots, and we are trying to disseminate this concept, the results of the pilots, and all the other resources and tools via a series of events, like the webinars we have, via also the setup of a students' association, which will be launched during this month officially, and then via specific events that we call academic standard days, which are organized by national SDOs and universities in various European countries. This is the, let's say, list of webinars and modules that we have so far available about the green and the digital transition. We have already delivered 3 webinars, so the ones for module 1, 2, and 4. Module 3 is only slides and video, already available on our website. Sabrina will put also the link to this material in the chat soon. And today we have module 5, how to achieve digitally sovereign and interoperable software solutions. Also in this case, we will have the recording of the webinar available, and also the slides available after the event. The webinar will last overall 1 hour, but we will dedicate the last part of the webinar, like the last 15 minutes more or less, to the Q&A. So wait until the end for the discussion. However, if you have any curiosity, questions, comments, or anything that you would like to share about today's topic, you can do so anytime you prefer, even before we reach the Q&A session. And so you can do it by writing in the chat of Zoom or in the Q&A box that is placed in the lower toolbar of Zoom itself. So I think this is it that I wanted to tell you to introduce the event. And now I will stop sharing my slides, and I will pass the floor to Bjorn. So welcome, Bjorn, and thank you for presenting today.
Thank you, Maria. It's nice to have this opportunity to give some presentations about important topics and very timely topics, I would say. Myself, Björn Lundell, I'm a professor here at the University of Skövde, and together with Jonas Gemarielsson, we are working in the software systems domain. So we are very much involved in the ICT domain and looking at all sorts of aspects to do with how to develop, how to procure, how to use various software solutions. And issues to do with geopolitical issues and digitally sovereign solutions are, of course, important. And the concept of interoperability is central to many of these kind of systems. And in order to achieve interoperable software solutions, there are a number of aspects. And in this presentation, the intention is that we will go through some of these important aspects. So let's see, we can start there. I want to start with some fundamental concepts. And software is something that has been of importance for a very long time. And it's clear that conditions for development and provision of software, that has changed during the history of computing. And in the early days, when organizations acquired hardware solutions, computing machines, etc., software was nothing special. It was just something that you got together with the hardware. And you could say that until the late 60s, software was not something that was procured separately. It was something that you brought along with hardware. But that has changed. And the importance of software has been growing, I would say, over time here. And also the way by which people engage with software. One example here is the large company General Electric. They write in their annual report that every industrial company will become a software company. And that says something about the importance of software for society. And that is something to recognize in these days. One way by which you can use software, and that is really software as a service. And it's clear that the capacity provided to the consumer is to use the provider's application running as a cloud instance. And NIST, the standardization organization from the US, gave this definition early on. And popular examples of widely deployed SaaS solutions, software as a service solutions, are like Microsoft 365 and Google Workspace. So those are examples of globally provided SaaS solutions that many organizations use today. But of course, there are also other alternatives to that. Software can be provided under different terms, as we said. And one way by which you can develop and provide software is to provide it as open source software. And we commonly see the acronym here, OSS, open source software. That is software which is provided under terms that comply with the definition, open source definition, that has been established in the late 1990s. And such software is made available under a software license that has been approved by the non-profit organization, the Open Source Initiative, that was established in the 1990s. And the definition itself, that is not a license, but it's really a specification of what is permissible in a software license for that software to be referred to as open source. And that's something that Bruce Perens, one of the individuals that was really at the forefront of building this or establishing this organization, the Open Source Initiative, in the late 1990s. Open source software is typically provided by specific projects, software projects, commonly referred to as open source software projects, on one or several collaborative platforms. And platforms could be like GitLab, GitHub, SourceForge, and others, where you share digital assets on those platforms under conditions which are sort of defined by the license. And commonly used licenses is licenses in the GPL family. We have something called AGPL version 3, GPL version 2, GPL version 3, LGPL, that stands for Library Commons, and then we have the MIT license. So it's a specific license. I'm not talking about the university as such here, even though there is some historical link to the university, MIT. And we have the BSD, which is the Berkeley sort of origin as well. And then we have the Apache license and the EPL and the MPL. So those are a few licenses which are commonly used by many software applications. So like the MPL here, Mozilla Public License. Some of you may use perhaps the Firefox web browser. That's something which is provided under the MPL license. So we will come back a little bit to this. We won't go into detail. And I should say that I'm not a lawyer, but we have worked with many lawyers over the years in our research, and some of the results that we have developed and that we will share in this presentation comes from such collaborative research. There is also another concept which is important that precedes this. And in the 80s, we have something referred to as free software. And free software is software which is provided under terms that comply with the free software definition. And you see a link here to that. So that's similar, I would say, but it has a different origin. And there was a lot of discussion initially and a lot of idealistic motivations initially. And the four freedoms, as it's called, the freedom to use, study, redistribute, and modify the software has been at the central point of thinking of this. Today, I would say that free and open source software in practical means it's more or less it has more or less the same effect. So in practice, some people use FOSS as an acronym. Even the EU in the recent regulation, the Cyber Resilience Act, has introduced the concept of FOSS. But that concept goes back to some research projects conducted early 2000, essentially, in the EU. But what is this? Really, it's about individuals and organizations and other stakeholders that engage with and contribute to FOSS project. They generally presuppose that they have all the rights necessary to use, study, redistribute, and modify FOSS that is being developed by such projects. So that's the essence of what free and open source software is. So when I use OSS or when I use FOSS, I use those terms more or less interchangeably today. It's clear that open source software has had a significant impact to society, both an economic but also a societal impact. A study back in 2012 identified that at least 114 billion euro, 31% of the software market per year, came from direct savings as a consequence of using open source software. There was also a large study that was conducted as commissioned research, which actually individuals from this EDU4Standards project has been involved in a previous project. And that study also identified significant economic value to FOSS. And the real essence of this, I would say, is that if investments in open source software were done, it would have a significant impact on the economy of the European economy. It was estimated there between 65 and 95 billion euro as a positive impact, essentially. It's very difficult to make these kind of estimates given the way by which open source software is being used, because the license, and that's clear for all open source licenses, you can actually distribute software in a cascade. So if I distribute something to a colleague, that colleague can distribute the software further, and it can be taken to other usage contexts. So it's very difficult to know actually how much a specific software application has been deployed and how much it has been used, given that the license as such gives all the rights for anyone to use that under that license. So there is no such thing as typically a contract that is needed. You can still have contracts for services and support and further development with commercial entities, but the license as such lacks such conditions. If we look at the open source software licenses, we can see that there are different categories or different types. Essentially, you could divide the open source software licenses in two categories. One is licenses that has a copyleft effect and those which lacks such an effect. A copyleft license is one that requires as a condition of distribution that you actually make the corresponding source codes available under the same license terms. Hence, if you distribute something, for example, under the GPL license, which is one example of a copyleft license, you need to distribute it under the same license if you distribute it further. We have done a study some years ago which investigated commonly deployed applications and saw that 60% of widely used projects are provided under one of the variants of the GPL family of licenses. It's clear that that number has gone down to some extent, but that doesn't mean that the number of applications has gone down. It's just that the increase of software applications under other licenses has increased much quicker, which means that the proportion of the GPL licensed software or widely deployed software is sort of not that strong today, I would say. But there are commonly used examples here. So like the Linux kernel is provided under the GPL license, which is a copyleft license, under terms which is fully symmetric. In other words, you get the same rights as you give if you contribute to such a software project. And that's an essential element of establishing and maintaining a good governance around a FOSS project. Standards is also super important in the ICT domain, and conditions for development and provision of standard has also changed during the history of computing. Many stakeholders have contributed to development and use of ICT standards, and there are a number of different standard setting organizations, or SSOs as it's called. If we look at specifically the ICT domain, there has been a long significant tension and disputes concerning what different stakeholders consider to be appropriate conditions, and there are different views there. And of course, different stakeholders have different business interests, etc., which is not surprising. And that's something that has caused some friction in between different organizations over the years. I should say that in the slide package you will get the references later on, so you can have a look at details if you're more interested. Essentially, you could say that standards could be provided either under FRAND terms, fair, reasonable, and non-discriminatory terms, or under royalty-free conditions. And many standard setting organizations, they have adopted various policies that allow for development and provision of ICT standards under FRAND terms. But there are also those that strongly favor royalty-free terms. And two examples are the IETF, Internet Engineering Task Force, and the Web Consortium, World Wide Web Consortium. Provisions of an ICT standard under FRAND terms allow for standardization patents to impinge on the standard. That means that there could be patent that impinge on the standard, which means that in order to use that standard, you need to obtain licenses for such standards. And that, as a consequence, can have implications for the way by which you can build and use such standards in software projects. The term open standards has also been coined in various contexts. And back in 2004, the European Commission, in its first version of the interoperability framework, coined that term and presented a definition. That definition has been used in Sweden in a Swedish report from 2009. And such standards which comply with that definition, those standards can be lawfully implemented by software projects which provide software under different license terms for both FOSS and also for non-FOSS. And when I use proprietary software here as a term, I really mean non-FOSS software. So if it's any other term, essentially. And the open source initiative, they have not presented a definition by themselves, but they have stated in a requirement that open source is sort of important. And for a standard to be referred to as an open standard, it must not prohibit conforming implementations in open source software. That's essential for use of FOSS there. So, to summarize, open standards constitute a subset of all standards, and open standards typically are irrevocably provided under royalty-free terms and can be used and implemented by FOSS projects without restriction. If we use that definition, which is used in Sweden and in the first version of the definition, it should be mentioned that open standard is also used with other definitions, which is something else. But I won't go into a lot of details about this definition history in this presentation. It has been researched that there is some sort of lack or limited research that address the relationship between software projects and how such projects deal with patents that impinge on standards. There is a study that we conducted actually and published a few years ago here that investigated 24 different software projects implementing ICT standards provided by 8 different SSOs. It shows that the majority of those 15 out of 24 of the investigated open source software projects are provided under copyleft conditions. So there are a number of standards implemented by software projects that provide open source software under copyleft, which is quite interesting, I would say. Having said that, it doesn't mean that you can't implement such a standard under other terms. That's perfectly fine. But still, there is an issue if you have that. Anyway, the FRAND licensing terms, there are different, as I said, business motivations for doing this. But it could be recognized here that back in 2013, the European Commission published a communication which recognized that FRAND licenses create barriers for open source projects. And there has been some research into this that there is no time to go into all of these details in this presentation, but there is plenty of research that you can have a look at after this presentation if you are more interested. Another concept which is important and related to the extent to which you can have interoperable software systems is the concept of lock-in. The concept of lock-in is a complex one, and policymakers has addressed this. And it's worth mentioning that just a few days ago, on the 3rd of June, the European Commission launched a new package of new legislation, or I should say proposed new legislation that covers this quite extensively, actually, the CADA. And they also launched an open source software strategy for Europe, which is quite interesting. But lock-in effects, it's not only technical, it's also legal and economic and societal. So there are both sort of technical aspects to lock-in, but also software aspects to lock-in. And there is a relation to competition if we talk about lock-in. From a competition perspective, it is often problematic when public sector organizations conduct IT procurement and express requirements for closed standards, in other words, standards which may not be possible to implement in FOSS projects. That is something that the Director General for the Swedish Competition Authority wrote in a preface to a research study that actually we have conducted, and you have the reference to it in the end of this slide package after the presentation. Lock-in, as I mentioned, has both technical and human aspects to it. The tradition of doing something in a certain way may cause people to behave in a certain way, and you're used to a way of working that can be referred to as cognitive lock-in. But there are also a lot of issues that can have implications if you're locked in. If you lock yourself in, you may end up in a situation where there can be competition issues. So lock-in imposed by a supplier that cause issues for a customer may actually result in breaches of competition law, such as abuse of dominant position. But lock-in as such is not necessarily unlawful. That's important to be aware of. But it's something to watch out for and something to consider when you build software and use software and before you procure something. So lock-in, if we move to the cloud-based SaaS solutions, it's clear that findings show that public sector organizations may be unaware of the way by which such solutions cause lock-in. And we have done a large study in Sweden and saw that there is an extensive unawareness about the lock-in that is caused by such solutions, which means that if you go into a solution, you may end up in a problematic situation actually. And that's something that needs to be considered before you do a procurement. What can you do then? There are a number of strategies to allow for interoperability and long-term digit preservation. It's important to refer to formats and standards which can be and has been implemented in software, which is an alternative to the currently used solution. If you don't have that, you may end up in a scenario where you are sort of locked into a specific solution, and that may inhibit or may even prevent migration or data portability to other solutions. So that's an important aspect to consider. To manage data and documents submitted to a public sector organization in a format, you need to have the licenses, which makes it possible to lawfully and also technically use the formats so that that format can be implemented in software and used in other solutions. That's also an important aspect. One aspect of open source software license is that such licenses are provided under perpetual terms, which means that the software that has been provided as an open source software license do not have a time limit. There is no time limit on the end of use, so to say, from that perspective. It has been showed in previous research as early as 2012 that major lock-in concerns and the risk for dependencies on specific proprietary services may be a risk. We have seen in Sweden that 97% of all the municipalities use one single solution, which of course can also cause issues from a security point of view. If you put all eggs in one basket, and if that supplier, for whatever reason, is no longer available in the country, that can cause issues, of course, especially if you lack an exit plan, if you lack the possibility to take your digital asset and process such assets in other solutions. So market concentration involving SaaS solutions can be really something to consider. And in Sweden, we have seen quite extensive discussions about this recently. And some of you may have seen the news from this weekend where some solutions provided as SaaS solutions is no longer available due to some export restrictions, which is something to consider before going into a specific solution. When it comes to implementations of technical specification or standards, there are, as I said already, a number of issues here. And there can be problematic issues in the sense that if there is a lack of clarity and detail in the specification of a specific format that we have seen in a large study we did of the PDF format, that can cause issues. It can also be that various software implementations may cover only a subset of the features in the specification. In other words, the software application covers only part of the specification. That can cause issues in the sense that there can be a lack of interoperability consequence of that because the software application cannot interpret the file. There can also be different kind of influences between the implementation and the specific when the standard is built, which means that if you have like a dominant implementation, and if that dominant implementation implements a certain aspect of the specification in a certain way, which may or may not deviate from the technical specification itself, it may still have an influence on the market in the sense that other competitive solutions may need to follow the dominant player instead of following the standard, which can cause interoperability problems as a consequence of that. And in this study that we conducted a number of years ago, we saw that patent issues are actually perceived as a concern by individuals involved in various open source software projects. SaaS solutions is something that also may require licenses for FRAND standards, and that can cause format lock-in. You have a quote here from one commonly used SaaS solution, which says that the customer must obtain its own patent licenses from any third party. And there are a number of rights holders here which you need to approach and from which you need to obtain licenses. And we have done a study which shows that we were unable actually to obtain such licenses from all those apparent holders. And when I say apparent SAP holders here, that means those that have declared that they control standard license patents that impinge on the standard. Having said that, it does not necessarily mean that those that believe or state that they control patents that impinge on the standard actually do so. But that's something for a potential legal dispute to sort out. But that's the qualifier. That's the reason for the qualifier. Apparent SAP holders is defined in that actually paper. So use of SaaS solutions under unknown terms and conditions is always inappropriate. The EDPB, the European organization focusing on data privacy, etc., they have identified that many public bodies actually have no control over the engagement of processors and sub-processors. It is clear that many SaaS solutions are provided by not only the supplier itself, but it can have a number of sub-processors, which in turn can have sub-processors. And in a large study that was published 2023, they saw issues to do with this. Lock-in is a challenge, and in a large project some years ago, that was recognized that this is something that many industry domains need to consider. Data can be highly sensitive, and the need for protection is very clear. And therefore, the possibility to do data migration to another infrastructure is important. And this was recognized in a large EU initiative here some years ago. And that's important for users' serenity. I think I will, in the matter of time, I will skip this one. Interoperability, as I said, it's really the intentional design of a technology, a product or system, which allows it to cooperate with other products or systems without restriction or difficulty, thus producing a reliable outcome and resource optimization. And the goal of such a system is to facilitate interaction between different software applications and to enable sharing and reuse of information among non-homogeneous systems. So federated systems is super important if you want to have an ecosystem of software solutions provided by more than one supplier. And that's essential, I think, for a long-term sustainable ICT domain, that there is competition amongst different providers of solutions. When it comes to interoperability, it's super important for many systems, and in the internet space and in the web space, there has been a number of considerations of this over the years. As early as 1981, John Postel formulated the robustness principle, the Postel's law is called. And that's really about that you should not behave in such a way that you make it difficult for those that should read something. So you should be as liberal as possible when you interpret something that is produced by some other system, but you should be strict and don't cause problems for others. I will come back to that a little bit later on in another slide later on here. Standards can be used as a lockout mechanism for new entrants if such standards are provided under terms which makes it possible for other actors to implement them. It could be for all sorts of reasons. It could be for technical issues, unclear specifications, etc. And when it comes to the internet, it's clear that many of the standards that evolved as part of building the internet, those were very much focused on providing interoperability between different systems here. And interoperability is close to the heart and the driving ideology behind this structure that constitutes the foundation for the internet and the web, I would say. Considering time, I think I will skip this one. Yeah. So if we talk about standards in the internet space and interoperability, there is a general rule whose application can lead to enormous benefit, and that is the Postel's rule there, basically. Be liberal in what you accept and conservative in what you send. And that's super important to consider because you could otherwise end up in a scenario where you have a lot of interoperability problems when systems cannot communicate as a consequence of different interpretations of the same specification. It could be that both actors that build two different applications have tried their best, but if something is unclear, it could be that two different interpretations cause issues at the technical level as a consequence of this. Standards and standardization patents. We have seen recently some high-profile lawsuits involving standardization patents that has made headlines in the US, Europe, and Asia. And it's clear that there are strong business interests behind this. And a patent, as you most likely are aware of, is something that gives you a time-limited right provided by the government, a grant that gives its owner the exclusive rights to practice. And there are a number of words there, which means that to make, to use, to sell, those rights that is important. And typically it's 20 years that you have that right. That's something that needs to be considered. And typically there are not only one patent that may impact on a software system. There can be a lot of different patents. And that's something that needs to be analyzed before you start to work with the software system and before you distribute software out of a software project. Back in the early 2000s, there were some EU studies which actually looked into implications of standards provided as open standards. And the term FLOSS was also used. The L there comes from Libre. I mentioned earlier FOSS, free software, and open source software. But there is also a term Libre software, which comes from the Spanish-speaking or the Latin-speaking countries, like in Italian, Spanish, and Portuguese, for example. So FLOSS is also used as an acronym for FOSS. It's clear that some of the work initially there was really significant in the sense of illuminating issues to do with the way by which you provide standards. If you provide it in such a way that you can't implement the standard in FOSS or in FLOSS, as it's called here, it will have an effect on the market because you will not make it possible for those that wish to use open source software provided under perpetual terms to implement such standards. Interoperability and portability is important. So interoperability is a broader concept, but the goal of portability is also super important, and we have that in the EU regulation. So the act, the Data Act, for example. The goal of portability is to enable solutions to move data from one application to something else. It doesn't have to be a cloud provision of the software system, but in other words, you need to have the possibility, both technically, legally, and for other reasons, to move your data and digital assets from the current solution to another solution. And that's key, I would say, for avoiding lock-in. If you can't move your data out of your current solution, it would be like renting a flat and moving in with your furnitures and not being able to move it out again just because there is something in the contract or something that inhibits you or prevents you from taking your furnaces out if you want to move and change flat to another flat. So that's a big issue. So portability is super important in this reason. Some years ago, a Swedish minister with responsibility for digitalization talked about the importance of this interoperability framework that we covered earlier. And this was the first version, which had this requirement for royalty-free conditions over the standards. So that's one aspect of this. I think I will move over this as well. And this one is the definition of the requirement for a standard to be referred to as open according to the open source organization, the open standards requirement from the open source initiative. I won't go into all of details here, but essentially there should not be any discrimination against implementation of the standard in FOSS for it to be referred to as open standard. So it's a requirement on the conditions in order for it to be referred to as open standard. That's what it's all about. The originator or one of the originators of the open source initiative has written early on about the issues of patents and its relation to standards. So in the second bullet here, there are two ways that you can end up in problems if you are unaware of the fact that there may be patents that impinge on a specific standard. Then you can end up in an unpleasant situation where you actually impinge on a patent without being aware of it. So it's important to identify and ensure that you actually have all the necessary rights before you start to use a standard. There are patent databases provided by various SSOs, but not all patents may be available in those databases. So it's a challenge to investigate before you start to use a specific standard, I would say. Procurement also has some regulations, and it goes back to 2004. After that, there are updated versions of it. But essentially, it's about stimulating a fair and competitive market. That's the principle behind public procurement. And that is something that you need to think of, because if you refer to something which can only be implemented by one specific actor, then it could be seen as a lack of equal treatment. It could be anti-competitive as a consequence of that. Sovereignty is a complex concept, and today it's timely and discussed quite a lot. And as I already mentioned, on the 3rd of June, the European Commission launched a new package of proposed new law. And last year, there was also a sovereignty framework launched, which was detailed on the 1st of June this year, actually. So that's a framework by which you can assess your degree to which a specific solution is okay from this perspective. Digital sovereignty has been defined in different ways. This is one aspect of this, and digital sovereignty refers to the ability of a nation to control its own digital infrastructure, data, and technology, independent of foreign influence or control. And there are other definitions as well. I won't go into details about all of that, but here we have examples from a state in Germany, Schleswig-Holstein. They have presented some interesting policy documents taking steps in this direction, recognizing the importance of this. Recently, there are also discussions about geopolitical aspects of this, and we have the security regulations, like in the US, you have the FISA 702 that may cause issues that can undermine or make it problematic for any organization in Europe, for example, to use such solutions. And that's something that has been at the forefront of discussion in many countries recently, in Sweden and other countries, I would say. Yes. There is also the concept of data sovereignty, which I would say is a subset of digital sovereignty. That refers to control over data, including data protection law, competition law, and national security law. And that's something that means that you have control over the data processing, irrespective of how you actually use your solutions. Yeah, I will skip this. So that's the presentation, and we have just to show here that there are a number of references that we have in this session. So thank you very much. And if anyone after this presentation wants to reach out, feel free to reach out to me or my colleague Jonas here, who is sitting here, or to anyone else in the project. Thank you.
Thank you. Thank you very much, Bjorn, for your presentation, very exhaustive. We have 10 minutes left for the webinar, so I'm now going to ask the attendants if anyone has any immediate reactions, comments, or questions. We can wait a minute to receive any questions either in the chat or in the Q&A box. We don't have any yet, but I think, as you said, Bjorn, it's fine even if someone wants to reach out later on. I think you have put also your email, right, in the slide.
Yes. Yeah.
Okay. So we will publish them on the webpage of this event, on the teachers tool, and yeah, maybe I can show where, or Sabrina, maybe you put it already in the chat. Yes. So if you go on this,
I think we can do a slight update on the slides there, because I don't think the email is there, but we will add that. Yeah.
Yes, let's add it.
I provide you a new version of the slide package. Yeah.
That's fine.
Before you publish it. Yeah.
And then I'm sharing again for anyone who arrived later the link where you find the webinars, including this one. And yeah, in the next few days, we will upload both the recording and the slides, okay, with Jonas and Bjorn's contacts.
Yes,
Okay.
I should say that together with me here, Jonas, we have collaborated over the years here. So many of these studies that we refer to, of course, there is extensive research done by others, but the research that we have done is sort of mostly done with Jonas and myself here, most of it. Yeah.
Great. Very nice. So thank you both very much. I don't see any immediate questions coming in. So I think we have only 5 minutes left. We can close earlier the webinar.
Yeah.
And thank you again. And thank you also to our attendees this morning. Have a good day. Bye-bye.
Bye.